Judgment in the matter of Morgan and others against the Ministry of Justice.
Lord Stevens will hand down the judgment.
This is an important case concerning whether legislation passed in 2021, the Counter-Terrorism and Sentencing Act 2021, retrospectively redefined or modified sentences which had been imposed some months earlier in November 2020 on 4 terrorist offenders, or whether the changes affected by the legislation merely changed the manner of execution or enforcement of those sentences. It is contrary to Article 7 of the European Convention on Human Rights for legislation to retrospectively redefine or modify sentences which have been imposed. However, Article 7 does not prohibit retrospective changes to the manner of execution or enforcement of sentences. The 2021 Act did operate retrospectively, affecting 4 terrorist offenders. Accordingly, the central issue on this appeal is as to whether the 2021 Act modified or redefined their sentences or changed the manner of execution or enforcement of their sentences. The 4 terrorist offenders, the respondents to this appeal, are Seamus Morgan, Terence Marks, Joseph Matthew Lynch, and Kevin John Paul Heaney. The evidential basis for their prosecution were recordings made of conversations between them at premises in Newry, County Down, which revealed, amongst other matters, that they each belonged to the IRA. On 10th January 2020, all 4 were convicted on their guilty pleas of various terrorist offences, including membership of the IRA. On 13th November 2020, the determinate custodial sentences were imposed on each of the respondents, varying in length, with the shortest being 3 years and the longest being 6 years and 6 months. After imposing those sentences, the judge, in accordance with Article 8 of the Criminal Justice Northern Ireland Order 2008, specified a custodial period of half of the term of their sentences, which gave rise to an obligation on the part of the Department of Justice automatically to release the respondents on licence when they had served half of their sentences. After those sentences had been imposed, and whilst the respondents were serving their sentences, the new provisions contained in the 2021 Act meant that instead of being automatically released on licence at the halfway points of their sentences, their cases would be referred at the 2/3 point to the parole commissioners, who would not direct their release on licence unless satisfied that it was no longer necessary for the protection of the public that they should be confined. However, the new provisions did not alter the end dates of their determinate custodial sentences. The end dates remained the same. The respondents appealed to the Court of Appeal. On appeal, they challenged the legislative changes affected by the 2021 Act on 2 grounds. First, they contended that the changes were prohibited by Article 7 of the European Convention as retrospectively redefining or modifying the sentences which had been imposed on them by altering the custodial period specified by the judge and by making release on licence dependent on the approval of the Parole Commission rather than being automatic. Second, they contended that the changes breached the quality of law requirements in Article 5 of the Convention, in that the changes affected by the 2021 Act could not have been foreseen. The Court of Appeal determined that there was a breach of Article 7.1 of the European Convention, as the penalty imposed by the trial judge had been subject to redefinition or modification of its scope. The breach related to both the increase in the length of the custodial period and to the role to be played by the parole commissioners in determining whether actual release on licence could occur. As the Court of Appeal considered that this conclusion was sufficient for the purposes of determining human rights compliance, it left to one side the question of whether there was also a breach of Article 5 of the European Convention on Human Rights. The Ministry of Justice now appeals to the Supreme Court, and the respondents cross-appeal relying on Article 5 of the Convention. The Supreme Court unanimously allows the Ministry's appeal and dismisses the respondents' cross-appeal for reasons set out in a judgment given by me with which the other justices agree. I will now briefly summarize those reasons. In relation to the alleged violation of Article 7, the determinate custodial sentences were the penalties imposed on the respondents for the offences which they had committed. The 2021 Act did not increase the length of those sentences in any sense. It is correct that after imposing those penalties, the judge turned to the distinct and separate task which related to the manner of execution or enforcement of the sentences, in that he specified the custodial period. However, just because there is judicial involvement in a measure which relates to the execution or enforcement of a penalty does not change the measure to one in which a penalty is fixed. Indeed, an analysis of the legislation establishes that the task of determining the manner of execution of the sentences was not wholly judicial, but rather was shared between the judge and the legislator. Furthermore, the only declaration which the judge made as to the penalty being commensurate with each respondent's offending came at the stage when he imposed determinate custodial sentences on the respondents. Accordingly, as the legislation only retrospectively altered the manner of execution or enforcement of the sentences, the Ministry's appeal is allowed. In relation to the alleged violation of Article 5, it was entirely foreseeable, if necessary with appropriate legal advice, that during the currency of a determinate custodial sentence, the arrangements for the manner of execution of the sentence might be changed, as here, by the legislator. The legislator must be able to keep pace with changing circumstances in determining a fair balance between the demands of the general interest of the community and the interests of the respondents in relation to the manner of execution of a sentence. Accordingly, as the legislative changes were foreseeable, there was no breach of the equality of law requirement in Article 5 of the European Convention on Human Rights. The respondent's cross-appeal is dismissed. As I have indicated, the Ministry's appeal is allowed and the respondent's cross-appeal is dismissed.
Thank you. The court is now adjourned.